Absolute individual rights, limitation upon the freedoms. Absolute individual rights cannot be guaranteed by any modern states. The guarantee of each of the above rights is therefore limited by our constitution itself by conferring upon the state a power of imposed by its law reasonable restriction as may the necessary in the larger interest of community. This is what is meant saying that the Indian Constitution attempt to strike a balance between the individual liberty and social control. Since the goal of our constitutional system is to establish a welfare state, is maker of the Constitution that did not rest with the enumeration of controlled individual rights, in accordance with the philosophy of laissez-faire, but sought to be ensured that where collective interests were concerned, individual liberty must yield to the common good, but instead of leaving it to the occur of determine the grounds of extent permissible state regulation of individual rights as the American Constitution does. The maker of our Constitution specified the permissible limitation in clause 2 to the 6 of Article 19 itself. The state in the context include not only legislative authority of the Union and the state but also local and statutory authority, municipalities, local board, etc. within the territory of India under the control of the government of India. So all these authority may impose restrictions upon the above freedom provided such restrictions are the reasonable and they are relatable to the ground of public interest as specified in clause 2.6 of Article 19. Thus, the Constitution guarantees freedom of speech, of expression, but this freedom is subject to reasonable restriction imposed by the state relating to the defamation, contempt of court, decency of morality, security or the state friendly relation with foreign state, incitement and offense, public order, maintenance of sovereignty and integrity of India. Decency of morality is not confined to the sexual morality alone. It indicates that the action must be conformity with current standard of behavior or propriety. Hence, the seeking votes and election on the ground of the candidate religion, it is a secular state, is against the norms of decency and property of the society. In the event that freedom of speech and expression cannot confer upon the individual in a license to commit illegal or immoral act or to incite others to overthrow the established government by force in lawful means, no one can exercise his right to speech in such the manner as a violative another man such a right. Similarly, Similarly, the freedom of assembly is subject to qualification that the assembly must be peaceable, without arms, and subject to such reasonable restriction as the imposed by state and the interest of public order. In other words, the right of meeting assembly shall not be liable to abused to create public disorder or a breach of peace or a prejudice the sovereignty or integrity of India. Again, all citizens have right to form association or union but subject to reasonable restriction imposed by the state in the interest of public order or morality or the sovereignty of integrity of India. Thus, the freedom will not entitle a group of individuals in enter into criminal conspiracy or the form of any association dangerous to the public peace or the make legal strike or commit a public disorder and to undermine the sovereignty of integrity of India. Similarly, though every citizen shall have the right to move freely throughout the territory of India or reside or settle in any part of the country, this right shall be subject to restrictions imposed by the state in the interest of general public or the protection of any scheduled tribe. Again, every citizen has to right to practice any profession or to carry on the any occupation, trade and business, but subject to reasonable restriction imposed by the state of interest of the general public, subject to any law laying down the qualification for carrying of a professional or a technical occupation, enabling the state itself carry on any trade and business of exclusion of the citizen. The Anuradha Vasin versus Union of India, the Supreme Court held the right of freedom of speech, expression, and freedom to practice the profession or carry on any trade, business, or occupation over the medium of internet enjoy constitutional protection under Article 19(1)(a) and 19(1)(g) of the Constitution of India. Any restriction upon the fundamental rights should be consonance with the mandate under Article 19(2) and 19(6) and inclusive of the test of proportionality. As pointed out earlier, one of the striking features, the provision relating to the fundamental right in our Constitution, is that every declaration of major fundamental rights attended with a certain limitation specified by the Constitution itself. In the United States, the Bill of Rights itself does not contain any such limitation to the right of the individual guaranteed by hereby, but in the enforcement of those rights, in the court had invent doctrine like the police power of the state to limitation impose limitation on the right of individual in the interest of the community at large. However, the explained above the Article 19 of our Constitution, there is a distinct clause attached to each of the right declared, containing of the limitation and restriction which may be imposed by the state on the exercise of each of the right so guaranteed. For example, while the freedom of speech and expression of granted, individual cannot use the freedom to speech and expression as the guaranteed, and individual cannot use the freedom to defame another, which the constitute an offense under the law, a law which may be made by the state under any specified ground, such as the public order, defamation, contempt of court, cannot be challenged unconstitutional or the inconsistent with the guarantee of freedom expression, except where the restriction imposed by law can be held unreasonable by a court of law. That is how the completing interest of individual liberty of the public welfare have been sought to be reconciled by the farmer in our constitution, as the Mukherjee J explained the reading of A.K. Gopalan, State of Madras. There cannot be any such thing as absolute or uncontrolled liberty wholly freed from the restraint, for that would lead to anarchy and disorder. The possession and enjoyment of all rights are subject to such reasonable condition as may be deemed to the governing authority in the authority of the country can be essential to the safety, health, peace, general order, moral, and of the community. The question The question, therefore, arises in each case of adjusting and conflicting interest of the individual and of the society. Ordinary, every man has the liberty to order his life as the pleases, so say what we will, to go where we will, to follow any trade, occupation, or calling at the pleasure, and to do any other thing which he can lawfully do without let or hindrance by any other person. On the other hand, for the every protection of these liberties of society must arm itself certain power. What is the Constitution therefore attempt to do, declaring the right of the people to strike balances between the individual liberty and social security. Article 19 of Constitution gives the list of individual liberties and prescribed in the various clauses of restraint, and it may be placed upon them in law so that they may not in conflict with public welfare and general morality. It is to it is way of interpretation of the word reasonable that court comes into the field, and each case when the individual complaint to the court that the fundamental right has been infringed by the operational of a law or an executive order issued under the law. The court has to determine whether the restriction imposed by the law is reasonable, and if the held unreasonable in the opinion of the court will be declared law, and the order, if any, to be unconstitutional and void. The expression of reasonable restriction seeks to strike test of reasonableness of a restrictions. The expression of reasonable restriction seeks to strike balance between the freedom of guarantee by any of sub clauses Article 19(1) and social control permitted by any of exception in clause 2 and 6. It is to be seen, therefore, the criteria of test have been laid down by the Supreme Court of determining whether the restriction is reasonable or not. The Supreme Court has said that a restriction is reasonable only there is a proper balance between the right of individual and those of the society. Where the lands between given to landless person as a social welfare measure to improve the condition of poor landless person, the condition imposed against the transfer for a particular period of such guaranteed land cannot be said to constitute any unreasonable restriction. The test of reasonableness should therefore apply each individual statute impugn and not abstract of general pattern for reasonableness can laid down the applicable of all cases. The nature of right alleged to have been infringed, underlying purpose of restriction imposed, the extent of urgency in evil sought to be remained thereby. The disproportions of the imposition, the prevailing condition at the time should all enter into the judicial verdict. Thus, the formula of subjective satisfaction of the government and its offices with an advisory board of review to material of such government seeks to override a basic freedom granted by to the citizen may be viewed as a reasonable only very exceptional circumstances in providing in, internment or externment, internment and externment for the security of the state, the within the narrowest limit and the curtail a right such as the freedom of association in the absence of any emergent or extraordinary circumstances. All the attendant the circumstances must be taken consideration, and one cannot be dissociated actual contents of the restriction from the manner of the imposition or made of the putting them into the practice. The Supreme Court has held the examining reasonableness of a statutory provision within the violative fundamental rights guaranteed under the Article 19. One has to keep in mind the directives principle of the state policy. The restriction must be arbitrary or excessive nature, or its excessive nature, going to beyond the requirement of the interest of the public, of the general public. No abstract or general pattern or mixed principle judge of the reasonableness of the restrictions can be laid down, so the universal application and the same will vary from case to case, as also regard the changing condition, values, the human life, social philosophy, condition, prevailing condition, and the surrounding circumstances. A just balance has to strike between the restriction imposed and social control envisaged by Article 19.6. A prevailing social values as also social needs which are intended to be satisfied by the restriction. There must be direct, proximate nexus, reasonable connections between the restriction imposed and object sought achieved by the act, and being so strong presumption in favor of constitutionality of the act will be naturally alive. It follows therefore that the question and reasonableness should be determined from both substantive and procedural standpoint. Hence, substantive and procedural reasonableness. In order the reasonable, the restriction imposed must have reasonable relation in collective object which our legislation seeks to achieve must not go in excess of that object. Or other words, the restriction must also greater than the mischief to be prevented. Legislation with the arbitrary and excessive inhibit the right cannot be said to contain the quality of reasonableness. Thus, object of an act to provide measure for the supply of adequate labor for agriculture purpose of the BD manufacturing area, but the order of the deputy commissioner made thereunder forbade all persons residing in certain villages from engaging the manufacturing BD during the agriculture season. The Supreme Court invalidated the order on the ground that the imposed and the unreasonable restriction upon the freedom of business, Article 1G of this engaged the manufacturer BD, because object of act could be achieved as legislation restricting the employment of agricultural labor in manufacturing BD during the agriculture season, or regulating hours of the work of the businesses making BD. A total prohibition manufacturing impose the reasonable, unreasonable, excessive restriction on the lawful occupation of manufacturing BD. While the foregoing aspect we may be said to the substantive aspect of unreasonableness there under the aspect which the procedural aspect relating to the manner in which the restriction have been imposed, that is to say, in order to be reasonableness, not only the restriction must not be excessive, the procedure or the manner of imposition of the restriction must also fair and just. In order to determine whether the restriction imposed by the law and procedurally reasonable, the court must take into consideration all the attendant circumstances such as the manner or its imposition, the mode of putting it into practice. Broadly speaking, a restriction or is imposed in a manner which violates principle of natural justice. For example, it is a seek to curtail the right of association or freedom of business of a citizen without the giving him a opportunity to be heard. It has also laid down that the absence of extraordinary circumstances would be reasonable to make the excessive exercise of the fundamental right depend on the subjective satisfaction of the executive. The right of hawking, carrying a business interest cannot be denied if they are properly regulated under Article 19(6) of the Constitution, but the hawker carrying a trade or business or payment of road cannot claim right under Article 21 to right to carry trade or business not covered by Article 21. Freedom of press. Thank you.